for the second set of a riveting panel discussion, which will be on the USA EB5 Investor Visa Program, the insights into new regulations, and all aspects that you need to know from the experts. This panel discussions will be moderated by Mr. Mark Davis, who is the Global Managing Partner and Founder at Davies & Associates. His experience in distressed real estate finance with one of the world's 5 largest law firms, along with his extensive experience of investment visas, has made him the counsel of choice for many EB5 investors and developers around the world. Mark is a popular speaker on EB5 across India, the US, and many other countries. So Mark, can we have you on stage, please? Please join us. You'll be sitting here.
This one works?
Yes.
Okay, good. All right, thank you. So let's get the others. So yeah, you heard everything about me. My name's Mark Davies. I've been in India for about a decade now. With the change in the Indian regulations, I have to consider spending less time in India after April the 1st. But it's been a great market and very much enjoyed being here. We're approaching many hundreds of clients we've guided through the EB5 program. Don't have much more to say, so let's introduce the panel. Oh, you're going to call them one by one. Okay, all right, sorry.
All right, so joining us will be Matt Mahane, who is the Chief Legal Officer and Managing Director, Pacific Casino and Entertainment Group, PCEF in West America. He's a licensed attorney who brings 15 years of experience in various aspects of commercial, corporate, and intellectual property, along with construction-related areas of law. As an officer and stakeholder of PCEG, Matt oversees all legal issues and contributes substantially to both PCEG and the projects it supports. And after that, we'll be joined by Mr. Matt Hogan, Vice President of Project Development, CMB Regional Center. He heads a team responsible for the identification, due diligence, and underwriting of projects. And lastly, we'll be joined by Mr. Dennis Tristani, Partner, IA Donoso and Associates, LLC. Mr. Tristani has significant experience in employment-based immigration, family-based immigration, and EB5 investor immigration. He has worked on thousands of individual EB5 petitions and has extensive experience with EB5 investors from China, India, Latin America, as well as complex source of funds-related issues. So over to you.
Okay, thank you. So let's get started. So it would be really helpful as we go through this discussion to make it useful for the audience. So who here is considering investing for themselves in the United States for a visa purpose? Who's interested in going with their family? Okay, a couple of people. Who here is agents? Who's an agent? Okay, so we've got like 3 people in the room and the other people don't exist. Okay, fair enough. So we're asked to talk about legislative reform, but I'm trying to sort of figure out what's going to be of interest to the audience. So with that in mind, why don't I start out by asking Dennis. Dennis, you're a lawyer. I guess you filed lots of EB5 petitions for Indian nationals. What are the sort of the big topics, if you will, of legislative reform that you think might be of interest to people in the room?
Thanks. Yeah, I think right now what's of interest are the new regulations. I'm sure many of you probably know that USCIS, which is the adjudicative agency that adjudicates EB5 petitions, they have promulgated and passed new regulations that took effect November 21st. Now these regulations are forward-looking, meaning that applications that were filed previously are not affected, but all applications going forward have to comply with the new requirements under the new regulations. And for the individual investor, what is probably most
These are the ones that came in at the end of November you're talking about?
Yes, that's correct.
Okay.
November 21st.
So if I filed my petition before November the 21st, I don't have to worry about this. Is that right?
Correct. Correct. And for most investors, what's most significant is the investment amount has increased. The old investment amount in a targeted employment area, which is a high unemployment area, which most EB5 investments would qualify for, was $500,000 US. That amount is now $900,000 US for an investment in a targeted employment area and $1.8 million for all other areas. For most investors, the $900,000 amount would be what most people would invest at. But for Indian nationals, it's something to consider simply because the LRS scheme allows an investment of overseas remittances of $250,000 every year per calendar year. So for families looking to invest, it is a considerable jump, and it's something to consider when
So let's pick that topic up. Change in investment amount. So Matt, you're with one of the biggest regional centers, and I know that you have like significant legislative sort of representation in Washington. So you have your ear pretty much to the ground on these things. One of the things I hear from our clients is certain lawyers tell them that there's lawsuits out there and that the 9 lakh amount may be going back to 5 lakh. I'm going to ask each of the panel what their thought is on that, but perhaps you can explain that and where you think that might be going.
Yeah, that's a great point to bring up. So, you know, unfortunately, I think the days of the $500,000 investment are completely over. First and foremost, the regulations that are currently in place have set that new price. Now, as Mark mentioned, right after those regulations were made active on November 21st, there was, within a week, a lawsuit filed to request a temporary restraining order and injunctive relief to repeal certain portions of those regulations, and in an effort to try and expand the areas that would qualify for the high unemployment regions, and then reduce that investment level back down to 500. And I think there were a lot of people in the industry that said, oh, wait, oh, this is great, this is awesome. But the reality is that I think it's a kind of just a, you know, it's a hope and a prayer for certain people within the industry that would ever work. So as Mark mentioned, there were some people going around saying, hey, I think that that's got a real chance. I think it's highly unlikely that is going to provide the relief that they're hoping
so
for.
Matt,
We'll never see it go back
Hold
down.
the thought. I want you to continue, but I just want to get sort of a soundbite. So Matt, you're a lawyer too. I just in 2 seconds, what is your thought on whether we're likely to go back ever to 5 lakhs? And then Dennis, I'm going to ask you the same.
Yes, I agree with Matt, the other Matt here, that I think that it is quite unlikely, if not 0% chance that they would go back down to 500,000. And just real quick, the biggest reason I look as a business person is just the financial way that they got to that number. You know, it's been 500,000 since 1992. And if you do the inflation from 1992, 900,000 is actually significantly less than it should be if you were just looking at, well, I bought a Toyota in 1992 for $10,000. It's not going to cost $10,000 now.
Thanks. Dennis, your reaction?
Yeah, I unfortunately have to agree. I was going to echo the same sentiments. The program's been around for 30 years. If you simply factor in inflation, the investment amount should be much more. USCIS has gotten loads of comments from congressmen, industry experts saying what investment amount is going to make sense for the market. And there's a lot of consensus that even $800,000, $900,000, even $1 million minimum investment is doable. There's still going to be a strong market for EB5 at that amount. Once you get higher than that, it becomes less likely that amount is going to be attractive. So long story short, I think the amount is here to stay. Even if there's legislative reform that changes these regulations, I think you're likely to have an investment amount increase at least to around $800,000.
So Matt, just back to you. So get it, right? People who do a lot of business in this country, and I happen to agree, by the way, nobody thinks that this lawsuit's going to succeed or has I mean, you can't say 100%, but 99% no chance of success. So accepting that we're at 9 lakhs right now, and I'm thinking of investing, where do you think the future's going?
Where do I think the future's going? I think the future, first of all, is if I had to guess, if there's going to be a change in the investment amount, they're going to go up again. The reason why I say that, and you had mentioned keeping our ear to the ground, it's something we are very active within the industry and the various stakeholder organizations, and we do follow what's going on in Washington. And right now, the legislation is actually looking to increase, and this is legislation that's put forth by a lot of stakeholders within the industry. Legislation is likely going to involve an increase again on that lower investment amount from $900,000 to about $1 million. And biggest reason why they're doing that is because they know that going backwards is not going to be attractive to lawmakers. They know that raising it might also be a bargaining chip that they can use to get some other relief for the program, things that could be good for the investors and good for the industry. So where do I see it going? I see it going up again, potentially, but at the very least, I see it staying at 900,000. And I do think that, as Dennis mentioned, those are still attractive numbers for a lot of the investors that we talk to. Right now, there's a bit of a sticker shock, I think, throughout the industry where people who had previously considered it are saying, yeah, maybe I don't want to think about it at 900,000, or maybe I need to take some more time to consider it. But one thing I would mention to you is that the reality is that this is still, and I know we'll probably talk a little bit more about this, but this is still one of your best shots at actually completing and actually immigrating to the United States on a permanent basis, through an investment program. This is the only investment program that allows you to immigrate to the United States on a permanent basis in the United States. So it's still your only shot to do that. I still think it's a great opportunity. It's a great value.
Thanks. Okay, so maybe we're going to see a potential increase still further in the investment amount. So Matt, other legislative changes that took place in November, right? Think about the EB5 program. It's supposed to be spurring investment in basically underprivileged areas, not to use the technical terms. How did that play out in the regulations? And if I'm doing project due diligence, right, what should I be concerned about given that?
Yes, well, I think that what we're kind of dancing around is the TEA issue, the targeted employment area, and how that is administered by the program. And to me, while the investment amount increasing, of course, is a very important change and one that you see first. To me, the TEA is more important, if not as important, more important than it, because it really affects, I think, the projects that are on the market. And you have to look carefully at whether a project qualifies under the new rules, and how many projects, many, probably hundreds of projects had to leave the marketplace because of it, or finish their offering and have to go to a much higher level. So the product out there, or at least right now, while everybody kind of gets their head around this, there's not as much product out there, so you have to be very careful to look at that and compare all of the projects to see where the safety elements are in those projects. The TEAs are now going to be administered by the federal government, and you can use very few census tracts, whereas in the past you could use lots of census tracts while you saw the large New York projects, Los Angeles projects, projects that didn't necessarily look like they were in underprivileged areas, but they were able to count census tracts to get there. Now, those days are kind of gone, and you have to use the census tract the project's in, and just the ones that are touching them.
Okay, so I'm going to ask two types of questions. First one is going to be to Dennis. Dennis, I'm going to ask, when you're looking at all of this stuff, how do I know whether the project I'm looking at is going to be qualifying for the lower investment band going forwards, and what does the certification from the US government look like, and how can I be sure of it? Then my question is going to be to both Matts, who both operate regional centers, to explain sort of their history with this topic, what they've done in the past, and sort of what it is that they do with their projects that, perhaps this isn't an issue.
That's a great question. So targeted employment area essentially means a high unemployment area. To invest in a targeted employment area, that allows you to invest at a lower threshold. Before the regulations came into place, the entity that would essentially certify that the project you are investing in is located in a targeted employment area were state departments of labor, state economic workforce agencies. So the regional center would contact the state agency, say the New York Department of Labor, and ask for them to certify that certain census tracts that surround the project you're investing in qualify as a targeted employment area. This letter, which is in the industry known as a TEA letter, was a very, very important document for any EB5 petition, because when the individual investor files the application, one of the many exhibits in the application is this targeted employment area letter. And that confirms that the investment can be made at a lower threshold, okay? The Immigration Service would still review that, but long story short, having that TEA letter was essentially a lock that that investment amount is going to be the lower amount, and the investors can move forward knowing that they've invested at the lower amount. The issue now is that the Department of Homeland Security, and more specifically USCIS, is making the determination that the state departments of economics and labor used to make. So what does that mean? When you apply for the EB5 process now, when you file your I-526 petition, you have to work with the regional center, and what you need to know is that the state agency isn't going to be involved at this point. They could be, but what's most likely is that the regional center is going to have a third-party expert, typically an economist, prepare a report using the same metrics as before, but essentially saying this project is qualifying as a TEA under the new regulations, which, as mentioned, are a bit more restrictive. So from an investor's point of view, there's, I would say, a bit more risk on you because you're applying and the agency, USCIS, is going to make that determination at the end of the process. Now, what's important to realize is that most regional centers have very, very good economists. You want to look at that report, work with your immigration attorney to make sure that the analysis that's been done, okay, is by a good economist, and that it is compliant with the current regulations, because that is what USCIS is going to be reviewing.
Sure. This is an incredibly important topic, and a couple of points of distinction, and Dennis did an awesome job of explaining that and walking through it. That the TEA letters that the states used to issue, the reason why people depended on those so heavily is because the USCIS, through a May 30th, 2013 policy memorandum, essentially said that they were not going to necessarily challenge the state TEA letters. And so what it meant is that if a state issued one of those letters, as Dennis mentioned, you could rest assured that you were not going to be challenged on your TEA. However,
right, which, Matt, if you think about it, always seemed like me a conflict of interest. Because if I'm the state of California, I want to spur investment. So am I very likely to say, sorry, I don't want your money, thank you.
That's exactly right. And that ultimately is what led to a lot of the scrutiny that the industry faced over the last several years, and is what has likely led to the USCIS pulling the responsibility of specifically adjudicating those without state help back from the states. They want to be able to look at those and control those. There was a lot of scrutiny in the media, primarily on the projects in New York. Wall Street Journal wrote several articles about some of the biggest regional center projects in the industry that had very significantly gerrymandered their regions, and through some help at the state were able to get those letters. Now, here's what I would tell you. The regional centers that used to rely on those, chances are they don't have projects right now, as Matt mentioned earlier. What's funny is that we have our own in-house economists. We have 3 in-house economists, and that seems crazy to a lot of people. We look at hundreds of projects every year. We only do maybe 8 to 10 projects every year. And so our economists have actually filed in the past their own letters without state agency letters, without state letters. And so we have approvals. We have many approvals on investors who have filed underneath or filed into CMB EB5 partnerships without a state letter. So we know that you don't need those letters. What you do need is competent economists who are not going to be doing anything tricky. Follow the rules that have been laid out. Use the best practices within the industry. Make sure that they meet the new criteria. And then, yes, of course, to the investor, there's a bit of due diligence that needs to be done to make sure that the regional center is trustworthy, that they have good economists, that they know what they're doing. And of course, your immigration attorney should lay some eyes on the work that's being presented that you're actually going to be filing. It's very important.
So, Matt, let me ask you a direct question. So when CMB when you think of the projects you've done, how many have been in Manhattan?
0. We've never done a project.
So is it true to say that CMB's projects are in what I would call natural TEAs? So in other words, they probably qualify under the new regulation?
Yeah, and what was actually one of the coolest things that I would tell you, one of the biggest project we ever did, which might have been one of the biggest single raises in the history of EB5, was actually in LA, qualified in 2 census tracts. Under the current rules, that project would still qualify. It's something we're very proud of. Historically, we've tried to be very conservative on these, which is why we currently have 2 projects in the market right now. We had 2 projects that we raised on at the end of last year. We didn't finish those raises at the end of last year. It was very easy to just convert those into raises under the new criteria because they qualified in regions that would have qualified. We built our pipeline that way to try and make sure that we were staying very conservative.
One of the things to think about is this. You know, Dennis and I are lawyers. We're agnostic to which regional center you choose generally. However, you know, they seem to fall into two sort of camps this way. There's either regional centers like Bruntley, I think both Matts, that tend to have all of their projects in sort of a natural area that this thing was supposed to be for at the lower level. And so you sort of don't have to worry too much. Or there's another set of regional centers who try to gerrymander the rules and to force. I'm not saying they're not improper, they meet the terms of the rules, but they gerrymander the rules to get a big project in a big city through the lower investment amount. And I think the US government is saying enough. Finish. Dennis? Sorry, other Matt, what do you think? How does your project work?
Yeah, I agree with Matt quite a bit, and I think there's a reason why you're seeing representatives from the regional centers like Matt and my own regional centers that were TEAs before this, very easy TEAs before this, 1 census, 2 census TEAs that still qualify under each of the rules. I agree 100%. Of course, with the very competent economist, you want that analysis done, and you want the economists to do more than just say, here's the facts. You want them to actually proffer that opinion, their professional opinion, because they will not do that.
Where is your current project, Matt?
Our current project is in Las Vegas,
okay.
Which qualified under the new, or under their old rules, but easily under the new rules as a 2 census track project as well.
Other Matt, where are your current offerings?
So we have 2 current offerings and a third one on the way. The first one is in Greenville, South Carolina.
So Greenville, South Carolina sounds like a major metropolitan area.
Not a major metropolitan area. You know, it's actually, yeah, and here's the thing. You know, a lot of people have only focused on these projects in New York City, Miami, Manhattan, you know, these places that, you know, are known on the international scene. And I'm sure there's great projects there too, but they didn't qualify. And unfortunately, those people got to be able to take on investors at that.
I might say you're doing these great little projects in small areas, but, you know, can you be successful doing that? Surely I'm more likely to be successful with a whacking great development in Manhattan. Or how long have you been in the industry, and how many projects and how many problems?
Yeah. So we've been in the industry for over 25 years. We've worked with over 5,600 clients from around the world, hundreds of clients from here in India. You know, we still have a 100% track record from an approval rate from our project standpoint. You know, if the investor is working with a competent immigration attorney, their source of funds documentation is accurate and it's within the law, the likelihood is you're going to receive an approval because our projects have never been denied. We've been very conservative in how we've structured our projects.
And I just want to say, too, from the perspective of looking at different projects, I mean, this is why you have to look at the nuts and the bolts of the project. To me, where a project is located is one of the least important things there is. You know, a project can be strong in any area, and a project can be weak in any area. There are lots of great Manhattan projects. There are also lots of not great Manhattan projects. Where it is doesn't really matter. It's, you know, the actual details. That's why you have to get into these projects and look at several of them, look at the different ones, what works best for you. You know, everyone knows what New York City is, but, you know, before I started coming to India, and if somebody told me, oh, I have a project in Mumbai or Delhi, I'd be great, I know where that is. But they could have told me 5 or 6 other cities that I have no idea where that is. In my head, I think it's in the middle of nowhere, but it ends up being a 10 million person city with huge amounts of economic gains. So you just can't, you just hear those cities and automatically think that's it.
And one of the things you have to look at is how's the project structured. So getting your green card or being in a project that may get likely to get you a green card is one thing. Another thing is, when I've looked at projects, I have a history in distressed finance. When I look at projects, the way most of them are structured, it's almost a complete pack of lies when they're telling you about this capital structure, because it can change on you the day after you set up. Now, Dennis, I haven't read his project, so it could be 100% clean. Generally, Matt's projects have protection in them that prevents them being able to change the deal on you. 85–90% of the projects in the market don't. So, you know, the rule that continues regardless of regulatory change is have someone who knows what they're doing, not just as an immigration lawyer, but understands the way real estate investment works. Because if you do, you're not going to get hosed. And there are some really good products and projects in low economic areas out there that can really secure you and your clients. Don't have too much time, so how many people here think that the price change is a big disincentive in India? So, okay, quite a lot of people. So one of the things we'll think about, if we can, is alternatives. Because of the price change, who's thinking an alternative to EB5? Ma'am, can I ask you what alternatives you're thinking of? The Grenada visa? So I don't think you mean Grenada visa. I think what you mean is there's a visa called an E2 visa. America has two investment visas, EB5, which gets you a green card, and E2, which gets you the right to go to America and operate a business. Our law firm has done many E2s for Indian nationals. But in order to get an E2, Indian nationals are not eligible for the E2 program. The way you make yourself eligible is one of two ways. Either you obtain nationality in a country that is E2 eligible, which is Grenada's one of the three, Grenada, Turkey, and Montenegro, or you marry somebody who's E2 eligible. You get one in one of those two ways. So, Dennis, you're a lawyer. We chatted about this to begin with. So, bearing in mind that a lot of our clients, and I think a lot of your clients, have kids going to school in America, talk to me about like EB5 versus E2 for a moment.
Sure. It's a very good point. The E2 visa is a temporary investment visa. It can be a very attractive visa if your goal is to live in the U.S., to operate a business. You can renew the visa indefinitely so long as the...
When you say indefinitely, does that mean for the rest of my life, potentially?
If the company is operational and that E2 business requires your managerial experience and you to be in the U.S. to direct the company, then yes. Now, in terms of permanent residence, having a green card to the U.S.,
Hold on a second, explain to me. You just told me that I can be on an E2 visa for the rest of my life. That sounds pretty permanent to me. So when you're now saying permanent residence, can you explain?
Yeah, it's a good point. So again, operations. You can come to the U.S. on an E2 visa, okay, to operate your business. You're going to have to renew that visa every year, or probably every 5 years if you have one from Grenada. That takes time. That costs money. Your family plans may change. You may not want to operate this business for the rest of your life. That business may not do well at the end. It's not a requirement that the business succeeds, but it is required that it's operational, that it has employees, and that it's essentially contributing to the U.S. economy. The E2 visa is not for the investor to simply move and establish a life for themselves. It cannot be a marginal business. It has to be more than marginal, and that means that it is producing enough revenue to have U.S. employees to contribute to the U.S. economy. The reason the EB5 green card has been so attractive for Indian nationals is because for most people, it's a passive investment. Most, 95, maybe 98, 99% of investors invest with a regional center. Many of them are F1 students. They're on an H-1B visa. They understand that the green card process after they complete their temporary visa likely involves a work-based employment petition with a very long waiting list. The EB1, EB2, EB3 wait list for India is anywhere in between 5 to 15, and you can even make the argument more years than that. So if the financial means are available, having the EB5 petition filed, there's going to be a waiting period, but for individuals who are already in the U.S., who have status, who can study and work, it presents a great option to eventually have permanent residency through a passive investment that doesn't require a lot of legwork on the investor's part as compared to an E2 visa, which is temporary and requires you to be there working all the time.
So what if I'm a student, right? My parents just gave me some money, and I have, let's say I have an E2 visa. I'm 22 years old. I was a derivative of my parents. I hit 21, right? And I graduate and I want a job. How does the E2 versus EB5 thing play out?
Well, so in the immigration world, once you're 21 or older, you're no longer considered a dependent. So if you had an E2 visa as a dependent because your parents, for example, had an E2 visa and you were in the U.S. as a dependent, once you're 21, you're going to fall out of that status. You're not going to have an E2 visa anymore because you're not eligible for it. Okay, so the child in that situation would have to find another visa status to move on to, whether that's through an employment offer, or perhaps just to go study and to stay in the United States until another option presents itself with employment. The EB5 visa, the green card, allows the individual to have a permanent path towards residency while they have another temporary status that allows them to work and or study in the U.S. So
if you have a kid, right, and the kid graduates, the E2 visa, if they're over 21, does them no good at all. Because most of them want to go get a job. They want to be they want to be in the Bright Young Thing program for General Electric or for Bank of America. You can't do that with an E2, right? For an E2, you've got to work for yourself. So for a lot of our clients, and I think your clients, right, too, Dennis, the E2 visa for a kid graduating for school is not the right product. Now, if you're a parent who wants to be in America, or you want to be in America fast, say you file your EB5, and let's talk about wait lines too. You say you file your EB5 and you're on a 3-year wait line, an E2 can get you in the United States in 6 months living there. So you can bring your family there and then wait, right?
Yeah, that's correct. I think it's a good option in terms of establishing oneself working in the U.S. while you have a permanent green card petition pending, like the EB5 visa, which there is a wait list, and you're looking at some processing delays and a wait list, maybe in the range of 3 to 5 years, I would say, probably closer to 5. But again, when you compare this towards other green card programs in terms of employment-based, the wait lists are much longer for Indian nationals. So if you're in the U.S., if you're pursuing a temporary visa, it's a nice option to have in terms of establishing permanent residency in the long term.
So ma'am, can I ask you? You're the one who mentioned sort of Grenada. Are those comments helpful, or do you have any questions we can answer? You're set. Anybody else with questions on E2 or Grenada versus EB? Yes, sir.
I have a different question.
Yes, sir.
How is that different with L1 visa? No, I know it's different.
Sure. So, Matt, are you comfortable talking about L1 visas? I'm just trying to give some, I know Dennis is a lawyer, but I'm trying to give some equal play here to people. So, L1 is an intercompany transfer visa, so perhaps you can explain some of the things about L1s.
Yes, with the caveat that I'm not an immigration attorney, but I've heard mine talk about this enough times that I think I can tell you the broad-based stroke on it. But L1, as Mark said, is an intercompany visa, so this is a visa option that presents itself for those of you that have businesses in India, and you can show that you've been employed by this company for at least a year over the last 3 years, and the company then would open a branch or some sort of division in the U.S. It is an attractive, also attractive like the E2 to get to the U.S. faster. From what I can tell, it is not very attractive as a path to permanent residence. Though there is a path, it seems to be a very hard path because a lot will rely on the success of that company's branch, which is going to be looked at by a regulator rather than a business person, so it's kind of a subjective thing. The same thing, if you are able to do it, it's one of those things where you can do the EB5 at the same time. The dual intent is no problem with the L1. Come here, start the branch, do the business, have the EB5 working in the background so that it can take it over.
Dennis, what's the maximum validity, ignoring recapture time and possible exceptions, what's the maximum validity on an L1 versus an E2?
So you're looking for an L1. There's two kinds of L1. There's an L1A manager or an executive to transfer a manager from abroad to the U.S. That's a 7-year visa. You have 3, 2, and 2, so 3 years, 2-year renewal, 2-year renewal, unless you start a new office. And the L1B, which is a specialized knowledge visa for specialized workers being transferred from a company abroad to a company in the U.S., that's a 5-year total time. E2 is different in the sense that there's no cap on how many times you can renew it, but again, when you're renewing the visa, an E2 visa specifically, the consular officer that's adjudicating that case is going to look at whether the company is operational.
And obviously, if I have my green card through EB5, there's a technical automatic renewal, or administrative renewal at 10 years, but ignoring that, I don't have to worry about renewals, right?
Yeah, that's correct.
So I'm done. I've got my green card and can turn it into a US citizenship if I want to. Sort of, as a lawyer, sort of question for you. if I was doing, assuming, because they asked about L1s, probably L1 versus E2 versus EB5, obviously, if I've got my EB5, I'm done. I don't have to worry about all of this stuff. But as a lawyer, if you have a client who's got, like, let's say a small business with just sort of 4 or 5 employees, they sort of have, you know, maybe there, maybe not on L1, would you rather have them on an E2 or an L1?
That's a good question. I think for an Indian national, the E2 process, if you don't have a spouse that's born in another country that has a treaty with the U.S., the E2 process is probably going to be more expensive. So if you're considering cost of capital and obtaining a Grenadian passport first, and then making an E2 investment as a Grenadian national, you're looking at quite a bit of money. You're probably looking in the range of anywhere between, I would say, $300,000 to $500,000 when all said and done. The L1 process, it's a good visa. It can be highly scrutinized when either the company abroad or the company in the US are small, because everyone wants to start their own business. And so that initial application for L1 is very important. You need a strong business plan, and you need a good plan for the future. If it's a small business, you need to be able to defend the business. Why is it going to do well? What are my marketing plans? How many employees do I need? Do I have a lease set up? Is my company ready to go? And the more set up your company is to go, if you've already have operations going on, that's going to be a stronger case versus one that's not.
So the one topic I think in legislative reform area we haven't really touched and we should do quickly is retrogression, time delays, visa backlog. So Matt Hogan, can you talk to us about that and sort of what's going on in that area and why? I have, you know, clients who call up our law firm and say, I just looked at the State Department bulletin, and I'd explain what that was, but we don't have time. And I see my date is current. Why don't I have a green card? So perhaps you can talk to us about delay, retrogression, visa backlog, what the difference is, and sort of what's going on and why.
Sure. So first and foremost, the delays exist on the front end, meaning that first petition that is going to be adjudicated, as well as on visa availability. So when you submit your petition to the USCIS, in the past, and it's going to change here in the next month or so, but in the past, they were adjudicating it on a first-in, first-out policy. And backlogs continued to increase based on the volume of petitions that they had and the complexity of the cases that they were adjudicating. And so in the early days of EB5, and I remember, you know, nearly 10 years ago when I started at CMB, a case that took more than a few months to be adjudicated was crazy. We were calling everyone we could for help and talking to local congressmen about, is there anything that we can do to apply pressure? I can't believe it's taken 3 months to get this petition adjudicated. Now, the posted processing times have fluctuated anywhere from, you know, 24 to, on the 24 months that we've seen on the low end over the last couple of years to, you know, 48 and beyond, 48 months and beyond. So it's, the processing times have gotten really out of hand. And so you have your processing time, and that's to get your I-526 petition approved. But then you also have the visa backlog. The program has a cap. It only allows 10,000 visas annually. And then each country is only allowed 700 visas. In the years past, China you know, was the biggest driver in this program and has eaten up the majority of those visas in the past. Now, over the last few years, India has started to use all 700 of its annual visas and is also waiting for visas to become available out of the additional 10,000 visas. However, they're stuck in line behind Chinese investors who have been in line for a long, long time. What we're seeing is a backlog in China, or I'm sorry, in India right now, that's probably based on U.S. State Department studies and things of that nature. What they've said is probably somewhere in the 6 to 6.5 year mark on their conservative estimates as far as how long it's going to take to receive a visa. And so you can understand from both of those angles, first and foremost, you have to wait a while to get that first petition approved, and then you're going to have to wait a little bit longer to actually have a visa that becomes available. So when Mark has mentioned there's, you know, your priority date and investors having current priority dates, that might mean that based on the date in which you filed, those investors in the past are starting to receive visas. However, in some cases, we have investors who don't even have their petition approved, their first petition approved, in order to step in line and actually receive that visa. So there's kind of been a bit of shuffling back and forth on these timelines, on delays, and now they're going to actually even change the process a little bit different, or to make it a little bit different, to start adjudicating based on visa availability. So what we may see moving forward is Indian nationals actually not even getting that first petition approved until the visa becomes available nearly 6 years into the future, and then at which time they'd be able to move forward with that visa.
So, do we have a quick question? We're running out of time, so we can answer afterwards. All these questions, we'll stand at the back near the white Italy sign, and we're happy to answer questions. Just to wrap this up quickly, so we're looking potentially at sort of, we talked about three things really. We talked about the last thing was these timelines, right? So you might be looking at 5-6 years to get your green card through the program, sort of a little unclear. Investment amount, it's only likely to go up, not likely to go down. And then the TEA thing, the answer to that is just screen the project properly and care for the regional center. But as I think about all of this, right, US is still, by far, the biggest market in the world. It's double the size of the Chinese market. It's a massive opportunity to be in the United States. And if you think about it, I was thinking we also have a law firm in the United Kingdom. We do the UK Tier 1. UK's program, similar to this, requires an investment of 2 million British pounds. We have an office in Sydney, Australia. We do the Australian program. The equivalent in Australia is in the millions. So even if it's 9 lakhs in the United States, if you compare that program to the United Kingdom, to Australia, certainly to Austria at 8 million euros, 6 to 8 million euros, the United States, I think, still looks like a bargain, really, compared to other things. And my clients, they want their kids to go to school in America. Right now, EB5, if you want your kid to get a job in America, EB5 really is, I think, the sort of best route compared to other programs in other places. So with that said, thanks to the panel. We've run out of time. That's my fault. Happy to answer questions afterwards.